Very good morning, students. Today we are going to see the provision relating to Stri Dhan under Hindu law. What do we mean by the term Stri Dhan? Do you have any of the idea about the term Stri Dhan? Let's see what the meaning is. Stri Dhan means a dhan, a property of a Stri. Stridhan means a dhan of woman. Now, what actually this comprise of? Let us see the definition which we get in our earlier or very important text written by Manu. What he has said about Stridhan. According to Manu, Stridhan as what was given before nuptial fire, what is given at bridal procession, and what was given as a token of love, and what was received from brother, mother, and father are considered as sixfold property of a woman. This is nothing but a Stridhan. What does this mean? Whatever the property which was given before a nuptial fire, which was given at the bridal procession, which was given as a token of love, ये तीन बातें हो गई, and what was received from brother, mother, father, ये हो गई रेस्ट तीन बातें. ऐसे टोटल मिला के जो सिक्स फोल्ड प्रॉपर्टी है, ये बेसिकली सिक्स फोल्ड प्रॉपर्टी वुमेन की प्रॉपर्टी यानी कि त्रिधन कहलाया जाएगा. Now let us see what the Mithikra Law speaks about Stridhan. According to Mithikra, the following properties are Stridhan. Properties that was given to a woman by father, the properties given to a woman by mother, and the properties given to a woman by a brother would be termed to be a Stridhan. Now, if we take into consideration the judicial decision in respect to Stridhan, then in that case, from the very beginning, from the days of Privy Council, the Privy Council in Takhar Denis versus Raibal Karan, in this case, court held that the immovable property which was inherited by a woman, the immovable property which is inherited by a woman from her husband is not a Stridhan, would not be considered to be a Stridhan. That is to again say that the definition of Stridhan is limited to the property which the woman actually received from her father, mother and brother. A part of that, the property which she received before the nuptial fire, at the time of the bridal procession, and afterward as a token of love, would be considered to be a Stridhan of a woman. Now, if we take into consideration the other case, then in that case, in Shri Shankar versus Devi, the Privy Council held that the property which is inherited by a woman, whether for a male or a female, does not constitute her Stridhan in any case. The share of a joint family property allowed to a woman is not a Stridhan. Even the gift of immovable ancestral property by a husband as an act of accession to his wife and fulfillment of his father's wishes and fulfillment of his father's wishes. Whose father's wishes? Husband's father's wishes. Then in that case, even that kind of a property would not be considered as one made for the pious purposes and to be treated as a Stridhan, and therefore this particular property would not be considered to be a Stridhan. So property inherited by women, whether for a male or a female, does not constitute her Stridhan in any case. Second, the share of a joint family property which is allowed to a woman is not a Stridhan. Next is even the property or even a property which is in the form of immovable ancestral property, and that too is being transferred by a husband to a wife in the form of a gift as an act of accession to his wife, and the fulfillment of his father's wishes cannot be considered as to be a Stridhan and is made for pious purposes. Now, a question comes in my mind is whether share obtained by a widow on a partition can be treated as a Stridhan. Whether a share obtained by a widow on partition can be treated as a Stridhan. Then in that case, the answer is no. The share of a joint family property which is allowed to a woman on a partition is not her Stridhan unless a contrary intention appears. Suppose if it has been declared at the time of giving a share of the joint family property to a woman, it has been clearly made mentioned that particular property would be considered to be or would be governed by the provision of Stridhan, then in that case only that particular property would be considered to be Stridhan, otherwise it would not be considered to be a Stridhan belonging to a woman. Now let us see on the basis of that what are the incidents of Stridhan. The Stridhan devolves on her death to her own heir. Stridhan जो है जो भी वुमेन के पास में है, वुमेन की डेथ के बाद में ये स्त्रीधन उसके बच्चों को मिल जाता है, यानी जो लीगल हेयर्स हैं वो एंटाइटलमेंट रखेंगे इस पर्टिकुलर स्त्रीधन को क्लेम करने के लिए. Now next is the woman can alienate the स्त्रीधन at their pleasure. कहने का मतलब है कि वुमेन जो है वो क्या कर सकती है, अपने स्त्रीधन को अपने विल एंड विश के हिसाब से चाहे तो किसी को भी एलिनेट कर सकती है, और अगर एलिनेट नहीं किया, डेथ हो जाती है, देन इन दैट केस उसके लीगल हेयर्स जो है वो उस पर्टिकुलर स्त्रीधन को क्लेम कर सकते हैं. बट अगर वुमेन जो है वो चाहती है कि वो स्त्रीधन किसी को दे दे, देन इन दैट केस वो अपने प्लेजर से स्त्रीधन किसी को भी दे सकती है. नाउ लेट अस सी द कंसेप्ट ऑफ वुमेन एस्टेट. क्या स्त्रीधन एंड वुमेन एस्टेट इज वन एंड द सेम थिंग? So before coming to this particular conclusion, we should at least go through what do we mean by the term woman state. Now woman state means what? All the property which has come to the woman by any means. All the property which has come to the woman by any means or a form, any or from any source whatsoever, and in which she has an absolute interest or only a limited interest in the property, would be considered to be a woman state. So what does this mean? This means that whatever the property which has come to the woman by any means, whatever the property which has come to the woman by any means, any way out from where she may get a property or from any source. The source may be anyone, like it is not necessarily to be given by the father, it is not necessarily to be given by the mother, nor it is necessary that it is to be given by the brother. It is not necessary that it is to be given at the time of bridal procession. It is not necessary that it is to be given at before the nuptial fire, nor it is necessary that particular property need to be given as a token of love. Any kind, wherever, any method, property which comes to a woman by any means or from any source whatsoever, if she is having an absolute interest over that particular property, or even if a limited interest over that particular property, then in that case, to that extent, that particular property would be termed to be a woman estate. Now let us see what do we mean by, because now we are considering the entire property to be belonging to a woman state. So now it become important for us to understand what are the incidents of woman state. The woman who inherit the property from her husband is the owner of the same, right? The woman who inherit the property from her husband is equally the owner of the same, but she could not sell that particular property, nor she can mortgage that particular property unless it is for a legal necessity, unless it is for the benefit of the state, unless it is with the consent of the reversionary, unless it is for some religious or charitable purposes. However, she is entitled to manage the estate as an absolute owner. Now let us see why I am using this. For the reason in our earlier slide, what we have seen that which she has absolute interest or only a limited interest in the property. We are using both type of sentence. One part of the sentence says that the absolute interest in the property is transferred to a woman, and the another part of the statement says that only a limited interest in the property is there. Still that particular property would be considered to be a woman's state, and in the later we may see the explanation that a woman who inherit the property from her husband. Now this is a source whereby a woman is inheriting a property. So this is one of the source whereby a woman is inheriting a property and therefore become an equal owner of the same. Like the husband was the owner of that particular property, and after the demise of the husband, the woman has inherited that particular property and thereby became a owner of this particular property. But if she cannot sell it, if she cannot mortgage it, then in that case we would consider the woman to be having a limited interest in that particular property. But she may transfer that particular property if there is a legal necessity for the benefit of the state with the consent of the reversioners or for any religious or charitable purposes. Then in that case, only in that situation, that particular transfer of that particular property by this woman to any person would be termed to be a valid transfer. Otherwise, it would not be termed to be a valid transfer. However, she is having the right to manage the estate as an absolute owner. As such, she can represent the estate, she can file a suit in the court in respect to that particular property. She may even face a litigation in respect to that particular property, and apart of that, she can sure to recover the possession of the same. For the reason why she can be sure to recover the possession of the same, for the reason if she suppose if she files a suit for the recovery of the possession of the same, but that in that situation, because she is entitled to manage that state as an absolute owner, definitely she will be having a right to recover the possession of the same. And in this way, we can say that woman state is different from Stridhan. So there are two different concepts, the Stridhan and the woman state. Students, we have gone through the provision of both the things. I hope you have understood the concept, and you, you have understood the concept. Thank